Imagine this. You just bought a business, you've closed, you're excited, everything's going your way. 6 months later, you get a lawsuit slapped on your hands for something that you had nothing to do with. Before you sign the dotted line on acquiring a business, here's a few tips and tricks you might want to know. My name is Dustin Lee. I'm the founding attorney of Ascend Legal Solutions. We're a business law firm based in Texas. We handle all types of business law legal issues, so everything that you can think of, from your formation, your estate documents, compliance issues, to your contracts, and even business litigation. Everything in this video is for educational and informational purposes only. Nothing in this video is legal advice, tax advice, securities advice, financial advice, or any other kind of advice. If you need advice about your specific situation, you need to contact a lawyer in your jurisdiction. And also, nothing in this video creates an attorney-client relationship. In this video, you're going to get a clear breakdown of how a transaction works when you're looking to buy a business. You're going to talk about the questions that you might ask, the things to look for, and where people usually get tripped up. Let's get into it. Okay, here's what we're going to cover. First, we're going to talk about the asset purchase versus the share purchase and what type of deal structure you may be looking at. Second, we're going to be talking about due diligence, both on the business side and the legal side. Third, we're going to be talking about the purchase and sale agreement and the other agreements that are going to be part of this transaction. Fourth, we will quickly discuss liabilities and what may be following you if you buy the business. Fifth is sort of an extension of number 4. Again, what kind of contracts and obligations may be following you when you buy this business. 6 is sort of post-transaction obligations that either party might have, including non-compete obligations from the seller. And lastly, why it's actually important to get an attorney involved on your side. Let's get into it. Okay, first we're going to talk about how a deal is normally structured. There's 2 typical ways to structure a business purchase deal. The first way is an asset purchase. In an asset purchase, the buyer is purchasing the assets from the seller and not the actual business. So it's not purchasing the LLC, it's not purchasing the corporation. The buyer is purchasing the assets from the corporation, from the LLC. The advantage of this, of course, is that the buyer gets all of the assets and none of the liabilities. On the flip side, you've got the equity purchase, where you're purchasing the actual shares or ownership interest or membership interest in the entity of the seller. This is where you're acquiring the whole entity, and that includes all of the assets and also all of the liabilities. This is typically the way the seller wants to set it up, because the seller doesn't want liabilities following them around and no assets to pay with. And where does it get complicated? Well, in the asset purchase, it gets complicated where certain assets don't cleanly get transferred over. For example, maybe you have existing contracts that can't be cleanly transferred over. Or if there's liabilities on some of the assets, like say, for example, vehicles or pieces of equipment, then those may be difficult to cleanly transfer over as well. Also, things like key employees don't cleanly transfer over in an asset purchase like they do in a share or membership interest purchase. And then on the flip side, with the equity purchase, obviously everything is a lot easier to cleanly transfer, but now you're getting all the liabilities, and the complication with that comes in your investigation and the due diligence that you're doing. So as you can see, the deal structure doesn't just determine what's sort of formalistic on paper. It actually is really important to determine what you're actually getting in the transaction, and also maybe the things that are following with you that maybe you didn't want. Next, we're going to talk about due diligence. Now, due diligence is the process of investigating this business before you buy it so that you don't get stuck with something that you're not expecting. You're going to be taking a look at a lot of different things and evaluating a lot of different things. And this is where buyers most often trip up. So I will see people come into my practice all the time where they've already done a deal, they didn't do any due diligence, and now there's big problems happening. So what we really want to try to do is avoid that by doing the proper amount of due diligence in the first place. There's a couple of different types of due diligence that you can be thinking about. So the first piece that you're going to be looking at is financial due diligence. You're going to be looking at tax returns. You're going to be looking at financial reports, bank account statements, cash on hand, things like that. You're looking at all these financial statements to get a complete financial picture of the business. Now, these typically are fairly challenging for a normal layman to investigate. So you may want to get counsel or a financial advisor to help you investigate that. Also, if you have a business broker, your business broker may be sophisticated enough to look into that for you as well. But at the end of the day, the burden is on you as the buyer to do your sufficient due diligence to make sure that the financial reports and the tax returns and everything with the financial picture of this business checks out before you buy it. You're also going to be checking out legal due diligence. This is where a lawyer might be able to help you. So legal due diligence is, say, number 1, is the entity correctly set up with the state? Have its legal forms been filed with the state properly? Has it been filing its annual reports? Things like that. It's going to be looking at, is the intellectual property of the business correctly owned by the business, and how is that intellectual property getting transferred over as part of this agreement? It's going to be looking at existing contracts with vendors and customers and employees to see how those things should be treated in the transaction process. It's going to be checking out things like lease obligations, regulatory obligations, going to be looking at licenses. There's really a lot that goes into it. And also, of course, checking out the litigation history of the company and any potential threatened litigation that may not already be filed. Now, how does due diligence differ between an asset purchase and an equity purchase? Well, in the asset purchase, it's a little easier to do because you're mainly looking to see, hey, are we getting these assets free and clear, no liens, or are they coming along with liens or other obligations that we need to handle? In the equity purchase, it's much broader. It's more of those things that I was talking about before: legal agreements, compliance, proper corporate filings, really the whole works. What commonly gets missed in this process? Well, number one, usually people are not properly evaluating the financials. It's really, really difficult for someone who's not sophisticated to just pass over certain things that would be a red flag to an attorney or a financial advisor. So it's really important to properly evaluate the financials. If you're getting the whole entity, if you're doing the equity purchase, there's lots of things that could be missed. Worker classification, like independent contractor versus employee side deals. I've actually seen this in my practice where the previous owner made side deals, unwritten deals with previous employees or key employees to keep them on. And now after the transaction happens, those key employees expect that side deal to be honored by the new owner, and the new owner didn't even know about it. You've got things like verbal contracts and commitments, and even environmental issues, things that pop up that you just really don't think about in an everyday situation that could potentially be liabilities that would follow you if you do the equity purchase. Due diligence is certainly the most critical part of buying a business, and good due diligence is sort of the difference between buying a good business that's going to perform well and do exactly what you expect it's going to do versus buying a whole set of problems for yourself in the future. So the business purchase and sale agreement, business purchase agreement, sometimes a buy-sell agreement, this is the document that controls the transaction. And again, this is not just a legal mumbo jumbo piece of paper. This is a really important document that controls the rights and obligations of the party in the transaction. So what does this agreement cover? Well, obviously it covers the things, the big pieces that you would normally see in a letter of intent or what you would normally see in a handshake sort of deal. The things that you usually think of, price, performance, how much, when, what do I get, what do I not get, what comes along with me, what stays with you. Those sorts of things are the things that you normally think of, but then there's a ton of legal language that can be protective for either the buyer, the seller, or both that needs to be included in this agreement. In an asset purchase, this agreement is going to talk about what assets are coming along with the buyer, which ones are staying with the seller, what the liens and other obligations are on those assets, the conditions to close, and what happens for closing and transfer of the assets. In an equity purchase, it's going to be talking about the actual equity, who owns it, how it's getting transferred, what the payment terms are. And these are just the very basics. Every gap in this agreement is a potential lawsuit down the line. It's also going to contain usually some representations and warranties of the parties. Usually, the buyer is going to want the seller to represent and warrant that they have title to whatever is being transferred, that it has not been liened up or transferred to someone else already. Typically, the buyer is going to want the seller to make very expansive and thorough representations and warranties. And then on the flip side, of course, the seller is going to try to rein those in a little bit and just be very limited in the amount of representations and warranties that they make. And then hopefully you can get together on a middle ground, something that satisfies everyone. Indemnification. Okay, this is something that we won't dive too much into. It's a little bit of a tricky legal topic, but this is something that I often see in my practice is not addressed in purchase and sale agreements that really does need to be. So indemnification is for what happens if someone comes in and makes a claim against the entity or the assets later on after the buyer has taken possession of those things. Is the buyer supposed to handle it, or is the former owner, the seller, supposed to handle it? And how does that process work? That's the indemnification part that really needs to be included in the agreement. Essentially, every term that you miss, everything that you didn't think of, everything that you didn't negotiate and get incorporated into this agreement is a potential gap that could cause one side or the other, or maybe both sides, problems down the road. So especially in an equity purchase, the buyer shouldn't just be thinking, what assets am I getting? But really, what liabilities am I getting? what problems are going to be coming with this business down the road for me. Okay, so how does liability transfer? Typically, if you're doing an asset purchase, the liability doesn't transfer. You're getting the asset normally free and clear. You could be taking it subject to some liens or doing a payoff or something of that nature, but in most asset purchase agreements, we're trying to get the assets transferred free and clear of all liens and obligations so that you don't have to worry about liabilities following you down the road. In the equity deal, it's the complete opposite. You own everything, including all claims, including all obligations and all liabilities, which could be an issue for you if you don't properly negotiate and document your deal. So what are some of the most common surprises that people miss in due diligence and they find out about after closing? They can be things like post-closing tax liabilities that you didn't know about, undisclosed contracts, verbal handshake sort of agreements that you didn't know about, agreements with key employees that you weren't aware of, undisclosed litigation that you maybe should have found out about if you had done a litigation search, but you didn't do the litigation search and now you're stuck with that. Or warranty or ongoing service obligations, sort of contracts or warranty obligations that the previous owner has made that you have now inherited. Now, good due diligence is going to reveal a lot of this stuff, but it may not find everything, no matter how diligent you are in your due diligence process. And that's why you want to craft a really strong purchase and sale agreement that could protect you against these things if you don't discover them in due diligence. Okay, let's quickly talk about contracts. So the business that you're buying runs on relationships, and not all of those relationships automatically transfer over, especially in an asset purchase. Now, if you're doing an asset purchase, the existing contracts with the business's clients, they don't automatically transfer over. They stick with the old business because you're not actually purchasing the equity in the old business. So each individual contract needs to be assigned. This also goes true for leases, vendors, the obligations of the business. If you're taking on any of those things, or if any of those things are critical for operating the business, like the leased space, or like the contracts with the vendors that may have a really good deal on the stuff that you need, well, those things need to be transferred over too, and you need to make sure that those get incorporated into the deal. Now, employees are a big one. Typically in an asset purchase, the employees are not getting transferred over automatically, and you need to be able to account for that. Essentially, just the key thing to keep in mind is contracts typically don't automatically transfer over to you if you're just purchasing the assets. You need to find a way to move those contracts over through an assignment or through a new contract with the vendor, the employee, or the customer. Okay, next let's talk about non-competes. So if you buy a business and you don't get a non-compete from the seller, you are essentially paying for nothing. So when you're buying a business, unless you're just buying it to buy up the liquidated assets and try to flip the assets or something like that, usually you're buying the business because you want to continue to operate and run the business. And even if that's an asset purchase and not an equity purchase, most of the time you're coming in to make one of these purchases is because you want to operate the business after the seller exits. Now, after the seller exits, if you don't have a non-compete, they can just immediately turn around and start competing with you. So there's a few critical things that you need as far as a non-compete, a non-solicitation, and a non-disclosure or confidentiality agreement. So first, on the non-compete piece, we're talking about an agreement from the seller not to compete with the existing business that you have purchased if you're purchasing the equity, or with your new business if you're just purchasing the assets. What you don't want the seller to do is turn around and immediately start a new business that's exactly the same, using all of their old customer lists and all of their know-how about how to run this business, and immediately start going out and selling to the same customers with the new business when you're the one who bought the old one. And now all of those customers are going to go back with the seller, and they're not going to go with you, and you've essentially purchased nothing. The good news is typically non-competes in Texas are enforceable in the business sale context. You have to narrowly craft them to exactly what a reasonable non-competition would be. We have a separate video on that if you want to check it out. But essentially, you're trying to tailor this non-competition agreement to be limited in time and scope and geographic area in a way that's going to protect you, the new business, or the equity in the old business that you have purchased, to make sure that it is of value and that you're getting what you paid for. If you have questions about how a non-compete should work, you should check out the other video. The second thing you can do is a non-solicitation agreement. So this also sort of falls in the same type of category, but it's a little bit different. Non-solicitation agreement with the seller means the seller can't come back and solicit either the former or existing clients of the business. And also, you're usually going to to want to extend that to the employees of the business as well, because you don't want the seller coming and recruiting all of the employees of the business that you just purchased to come over to the seller's new business. The final critical thing to think about in this category is a non-disclosure and confidentiality agreement to make sure that the seller does not disclose or use any of the confidential information that you have purchased as part of the business in order to go out and start the seller's own business or allow someone else even to compete with you. You want that confidential information that belongs to the business to stay with you so that you can protect it and use it in your new business. Essentially, you have paid for goodwill and you've paid for these assets or equity as an ongoing business, something that you're going to run and try to run profitably and make some money from. And it just completely eliminates the value for you if you fail to get a non-compete, non-solicitation, and confidentiality agreement from the seller. Now, real quickly about why it's important to get a business lawyer to help with your business acquisition. Obviously, it's really important to get a business lawyer for really any business transaction that you're going to be performing, including the business acquisition. You can pay an attorney a little bit of money on the front end to make sure that everything is done properly, that due diligence is done properly, that the contract is drafted properly, and that you as the buyer are protected, or on the flip side, if you're the seller, that you are protected, to make sure that all the essential terms get incorporated into the agreement, that the parties know what the obligations are, and that the agreement goes out without a hitch, or that you're informed about what the potential pitfalls or liabilities are and give you the information that you need to potentially back out of a deal if you need to protect yourself. It's important to get an attorney involved in something like that, like it is for any business transaction, because if you pay a little bit of money to an attorney on the front end, it's going to save you a fortune on the back end in litigation costs and other expenses that can potentially jeopardize or even bankrupt the business that you just purchased. In my practice, the most common times that I see buyers involving an attorney is right at the beginning, whenever they have identified a business that they would like to purchase. Then they go ahead and get an attorney involved, starting with the letter of intent phase. They get the attorney to draft a letter of intent, the potential deal terms that they're talking about, or if the seller has presented something, or if the broker has presented something, getting an attorney involved. The next most common time in my practice that I see buyers contact an attorney is right after they have signed a letter of intent or agreed on the basic deal terms. And so now they need to get the due diligence done and the transaction papered up. So both of those are, as you can tell, right at the very beginning, because the value in an attorney is, number one, in that due diligence process to make sure that your interests are protected and that the business is what has been represented to you. And then the second value of the attorney early on like that is that you get all of the essential terms and everything that we're talking about here today, and really so much more, included in the business purchase and sale or asset purchase and sale agreement. Essentially, the role of the attorney in a situation like this is to help with the due diligence process, to advise on the deal structure, like an asset purchase versus an equity purchase, and then of course to actually draft and negotiate the deal points and the documents. So if you're looking to buy a business, if you're the buyer, or even if you're on the selling side, I do certainly recommend that you get an experienced business law attorney to help you out with your transaction. Contact someone with experience in your jurisdiction to help you out. So in this context, a business transactions attorney is not just sort of putting things on paper. They're actually helping you identify, is this a good transaction for you to enter into? And then if so, making sure that everything is clearly and properly documented. So as you can tell, there's a lot that goes into purchasing or selling a business. Obviously, we've got the structure of the transaction. Are we buying the assets or are we buying the equity? Identifying the due diligence process and working through that very carefully and thoroughly. And then, of course, evaluating what liabilities or obligations are coming along with this. And then also, how do we get the things that we need, like the contracts that need to be assigned over. We've talked about the key pitfalls and things to look out for. Obviously, this is not a fully exhaustive list. There's lots of things that come up in a transaction that can't be covered in just a quick video like this. We talked about non-compete, non-solicitation, and confidentiality agreements to protect you after you have purchased a business. And then, of course, we talked about when is it appropriate to get an attorney involved. So I hope all of this is really helpful information for if you're looking to purchase or sell a business. And of course, if you need help on something like that, you need to contact an experienced business law attorney in your jurisdiction. Now, as part of this, we identified in the due diligence process that one of the key risk factors is verbal or handshake agreements that the seller may have made with employees or customers or vendors even. And if you're interested in learning a little bit more about verbal agreements in the state of Texas, you should check out our other video. I'll see you there. Thanks, y'all.